Just very quickly, I'm going to just look at some data points because I think this is always really important. And what is critical to know, and this is, I've been following this venture source data for about 10 or 12 years. It is pretty amazing that the Bay Area ultimately always grabs about anywhere between 1/3 to 40% of all venture dollars that are invested. And that's critical because, you know, you are in the right place. There's a lot of money here, but this is nothing new to you. The other thing, just to some of the most active VCs, as you saw Tim Draper earlier today. Well, he's one of the top VC with one of the top VC funds, as you can see. And I wanted to give you a little bit of just a quick glimpse as to what the differences are between the U.S. markets and European markets. There's also some data on Israel and other places at this point, but it is clear that the U.S. venture market is still the most active market, but at the same time, you know, the reason for it is, of course, that a lot of companies, European companies and companies from everywhere in the world, come here to get money. There's just a very quick summary as to what industries are getting the money, and again, this is all in the documents. One of the things that always surprises people, and I think it is quite amazing, is that France always gets a really bad rap internationally, but it is actually in Europe one of the big leaders when you look at where venture money is invested. UK, of course, as well, but Germany really far behind. Reason is that the venture industry in Germany and other places are just not the same. So the biggest question that comes up when I work with new entrepreneurs, I was just working with some people this morning from Ukraine, is where do we go? What do we do? And the intuitive thing here in the Silicon Valley, and the cookie cutter thing, if you will, is to incorporate in Delaware. And that would be something that most of you are going to do. And the reason for it is, of course, that yes, Delaware is the place that all VCs understand and love, and we as lawyers love it because it's flexible, it's a great place to be. But it sometimes doesn't make sense. And as you heard earlier, for example, from Tim Draper, there are sometimes jurisdictions that you need to choose because it's a necessity for you to be able to actually do the work wherever you want to do it. For example, when you are a company in China, most likely you're not going to have a Delaware Topco. Most likely you're going to have a Caymans or a BVI or other entity. If you are going into India and you want to have operations in India, well, most likely you're going to go into Mauritius. So these are the types of things that you need to knock out very quickly. And the biggest problem here is this chicken and egg thing, is that you don't have the money at that point. You don't have the funding yet, and you really need to figure out, where do I need to be? If you're a Russian company, and this was something that I dealt with my client Wikimart, we had to figure out where to put them. We ultimately put them into Cyprus, but only after actually already having incorporated them into Delaware. Well, this was a big problem and cost them a lot of money. If you look at Yandex, we actually our firm took Yandex public this year. Was a company that was actually ultimately based in the Netherlands. So, I mean, there's a lot of tax structuring and thinking that goes into it, but at the same time, again, the biggest problem is you don't have the cash to actually do all this tax structuring at this point. So often, of course, you have to just go ahead and do it and move ahead and worry about these issues later, because you know, tax issues are sometimes the last issues that companies and entrepreneurs deal with, because first of all, you hope that you're going to be gone, long gone, by the time these tax issues really come in and bite you in the ass. But ultimately, it is something that you should worry about, and not always is Delaware the right jurisdiction. Sometimes, actually, we are also counseling people, why are you not in your home country? It really also will depend as to what are your projections, where's the money coming from, what are your markets, the markets you're going to be serving. Again, Delaware is so popular because the U.S. is the biggest market. So obviously, if you think that 80% of your revenues are coming from the U.S., it's probably the best place. So those are things that we talk about. Just very quickly touch on IP holding companies. We have this issue all the time where people ask us, why should we bring in the IP into the United States if it's currently outside the United States, if you are an international business? Big issue, big question. As you know, some of the multi-billion dollar companies around the corner here had big days in court, on tax court, about these issues, because IP holding companies keeping and holding IP offshore can be very interesting, because you could potentially wait for a tax holiday and then repatriate the money again. Those are things that startups don't give a lot of attention to, but it's something that you need to worry about at one point, and it's always something that we kind of keep on the radar screen, and we will bring this up hopefully at the right time. Again, I'm just rattle through this because this is kind of a silly question, but sometimes I get these questions. Shouldn't we be an S Corp? Well, if you don't have any foreign owners, yes, you can, but it's not really a place. It's not really a place for a venture-backed company. They're looking for venture money. The most likely, the right entity is a corporation, a C corporation, which again can be an Inc., limited, incorporated, whatever you want to call it. And the key components, of course, always in all of these things are really, what do I want to do? I want to limit liability. Of course, founders, I don't want to be liable for things that the corporation does. Taxes, as we discussed, IP holding companies, those types of things, and then sometimes name choice. So if your name in Delaware is absolutely not obtainable, maybe we can go to California, maybe we can go to Washington, maybe we can go to Illinois or other places to get the corporate name. We may not have the trademark, but we may get the corporate name. Or maybe we have the trademark but and the URL, but we don't have the corporate name. Those are the types of things that go into this. And the other question we often get is, well, I'm not really looking for venture capital. I'm actually looking for seed money. I'm looking for just some angel money, what have you. Well, the truth of the matter is, most likely you're looking at a venture capital transaction. And either it's a precursor to a venture capital transaction or it's something leading up to it. But there is, of course, always a possibility that actually it's not. If you self-finance, if you have cash, or if some of your family has cash, why go to a VC? I mean, there are lots of different ways to get to an exit, or maybe not to an exit. But one thing is clear: if you once you are looking at venture capital money, it is a situation where there will be and should be an exit, because last time I checked, the VCs are not .orgs, and they really need to get the money back out to the limiteds. And the only way to exit, of course, out of a company is either, an M&A transaction, or an IPO, or a secondary transaction. But that's not very likely, or not something that people really look to. So, some of the things we are looking for is in venture capital finance are securities law compliance. So we are very careful, of course, and this is really because we're looking for successful companies as to who do you sell your stock to. The last thing you want, and I'm sure you've all seen it, is a link on your website that says, we are currently raising a Series A. If you would like to invest, click here. And by the way, this is a lie. This is an actual example. I've seen it, completely innocuous. It was a company out of India, and phenomenal company, by the way. But the CFO didn't know about securities law compliance. You cannot make a public offering of stock. You only can do that if you actually do a public offering and you file a prospectus with the SEC. Again, most of the people who have the money to invest in you are actually qualified and accredited investors, but just be careful about general solicitation. Those are the things that I always tell new entrepreneurs, and especially foreign entrepreneurs. So what do we have? We typically, of course, have a couple of important things. We've got transaction documents that we need to deal with, and that's going to be in the actual presentation, and I will touch on some of them. But don't want to bore you too much with these sort of more technical things, but clearly the deal terms. And so we've had so many times, I've had situations where entrepreneurs come to me and say, we got the greatest term sheet. I said, why? Well, we got a $20 million pre-money valuation. Okay, great. But what does the $20 million pre-money valuation come with? And just suffice it to say that the groundwork or the things that you're going to be dealing with in a venture capital transaction are, of course, the first thing, the term sheet that you're going to get served up. And by the way, you are not serving it up. I've seen this a couple of times, and I'm not saying that doesn't happen. It does happen. Sometimes actually people put together a term sheet and say, these are the terms that we would like to use for our financing. But most likely, in 95% of the cases or more, the venture capitalists are going to serve up the term sheet. So make no mistake about that. The documents that you're dealing with are typically, stock purchase agreement, the certificate, which is the charter, investor rights agreement, voting agreement, right of first refusal, and co-sale agreement. And if you don't believe it yet that lawyers get paid by the words, I guess now you see so many agreements, and yes, we do put all these things in place, but they have a reason. There's always a reason for it. Very quickly, stock purchase agreement, what does it do? It actually sets forth the representations the company is making, sometimes the founders are making about the company. And there's a long list of different things. You're going to tell people that the IP is clean. You're going to tell people that there are no issues with the employees. There's no litigation. There's all these things that are not happening with the company. A certificate of incorporation actually sets forth, very important, all the economic rights, or most of the economic rights that you're going to have as an investor, and of course also the rights or the restrictions that you have as founders in the company. Investor rights agreement usually deals with most U.S. securities law issues. That's usually registration rights, but also preemptive rights so they can continue to invest. And the voting agreement is usually just among the company, among the stockholders, the major investors, but also with the founders, because you're ultimately putting in place drag-along provisions where you tell people, in this case, if 2/3 of the investors, for example, vote for a deal, you founders are going to support us on this deal, and you're going to vote your shares with us. That's in the voting agreement. Right of first refusal and co-sale agreement, usually just against the founders. Basically, as you heard earlier, again from Tim Draper said, or was it Tim? I'm not sure. No, actually, it was an NPR this morning. I listened to a program. They said, like, what are the 5 investing principles? Like people, people, people. People, people, people. Well, because I invest in your company because of you and because of this founding team. And that's why if you guys are selling, I want to know, and I have a right to either buy the shares from you, or I'm allowed to co-sale. I'm allowed to also tag along and actually sell my shares along with you. That's typically in those agreements. In the term sheet, of course, and that always comes up to me, it's just like, why do we sign a term sheet? Because it's non-binding anyway. Well, that's actually true. Most of the time, frankly, it's a moral obligation. People feel like, okay, we signed a term sheet, but really, if you look at it, it's completely, it's open until you've funded, until you've signed the investment document. There's nothing that's happened, except for probably 3 different things, and that's the no shop and exclusivity. And I always fight, frankly, with my own clients who are entrepreneurs. I say, of course, you're going to give them some exclusivity. Do you think they're going to deploy their lawyers and run up, $25, $35 or more $1,000 to do due diligence and run through the documents, and then you do a switch and bait, and then use them as a stalking horse and move ahead with something else? They want some exclusivity for a reasonable period of time. Usually that's 30 days or 45 days or 60 days, depending on how complex the deal is. Confidentiality. Also, they may not want you to actually shop this. They may say in the term sheet, hey, I want you to sign this and tell us and obligate yourself that you're not going to take this around and tell other people what we offered you, because we don't want you to use us as a stalking horse. I think this is critical. At the same time, people do play games, and until it's signed, they think they can shop it. I think it's ethical issue, and you have to decide for yourself as to whether or not you want to be one of those people. But that's the kind of stuff you're going to expect. And then expenses, of course, who is going to pay for certain expenses? That may be a binding provision as well. I'm actually going to, because I already told you about what these transaction documents do and what a certificate of incorporation does, I think the most important thing here is that this is the only document that actually gets filed. And again, this is the same thing wherever you are. If you're in Cyprus, if you're in Mauritius, in other places, in most situations, the only thing that gets filed is the charter. So the only thing that actually publicly is available to other people to look at is this charter, and it does establish the rights, preferences, and privileges that people have. What does that mean? And we're going to get into that just very briefly. Again, we talked about investor rights agreement, what they do. One of the things I didn't mention here is the information rights. Sometimes you get special information rights. Voting agreement we already talked about, and the right of first refusal we talked about. So on the deal terms, the term sheet again will be there won't be that much in it. It was like 3 or 4 pages. Some people are a little bit more elaborate, but clearly the most important thing that you're looking for in the term sheet is what kind of pre-money valuation are they giving you, what kind of post-money valuation are they giving you. But there is a lot of nuances in that, of course, because the pre-money valuation is based on what? Is it based on currently outstanding shares? Is it based on currently outstanding shares and a pool that we're going to set? You know, those are the types of things you should discuss. And this is not something you should leave open, because I've been in that bad position many times where we're going to have to haggle as to whether or not the option pool is included or not. And I think it's unfair for both sides, frankly, to not know this very important issue. You know, one thing I want to talk about is, there's something I don't have in here actually, is founder representations. So I get this often from serial entrepreneurs in the Silicon Valley who obviously already have hopefully made some money. They ask me, so why should I give personal representations because it's the company? And you know, if it's a very early stage company, it's very difficult for a VC to say, okay, well, the company's making these representations, founders are not giving any representations, but I'm going to rely on that. But you are really the company, so why can't you give the representations? And you're not standing behind it. This circle is like, you know, that keeps going around and around. And it's really a question. Sometimes it's a fund question. Some funds just don't ask for founder representations. Others do. But it is significant because you're setting the tone. And this is something I want to mention here. And I always talk to my VC clients as well about this. You are setting the tone, and you're potentially setting yourself up also for, you know, more stringent terms later if you are setting a certain tone, or you're setting a tone that is very company friendly and more a situation where you feel like, you know, it will be a win-win situation. You're not protecting yourself constantly. And that goes especially with respect to indemnification and other things, and some other terms we're going to talk about, like redemption, where people wonder, are you actually just protecting your downside, or are you protecting your upside, which is really the liquidation preference discussion that we're going to talk about. And this is really the most important thing. I think almost every VC will agree that between valuation, of course, I mean, that's of course really a key point, the liquidation preference is really the most important term. And here, this is where I think we have a lot of discussions quite often. You know, what kind of liquidation preference are you looking for, and what are we talking about when we talk about the pre-money valuation? That's great, and we have a liquidation preference that's not great at all, or almost impossible for the founders to make, or the entrepreneurs to make money. On the with respect to non-participating preferred, it's pretty easy. You know, the rule of thumb, if you just say you get 1x your money back, that is a great term. Frankly, if they just say, okay, if it doesn't work out, frankly, I get a 1x of my money back, and I don't participate in that situation. But I would just like to mention this again. Of course, if there's a home run, the investors are going to convert the preferred into common. So ultimately, if I make a quick example, if you have a $10 million pre-money valuation, and you have a $5 million investment, you have a $15 million post-money valuation at that point. If there's a 1x liquidation preference, then, and the company gets sold for $10 million, not a great deal, obviously, because post-money was 15. Well, then, in a non-participating preferred 1x liquidation preference scenario, the preferred the investors take back $5 million, even though they only own 1/3. If you look at it, 5 million on 10 pre, they take back half because of the non-participating preferred. If, on the other hand, you have obviously a 2x liquidation preference, you take all the 10, you take 10 back. But if it's participating, it's a completely different scenario, because then not only do you take, your money back, but then on top of that, there's some nuances, as you can see here. You would take, again, you would participate pro rata, 1/3 of the other of the 5 million, you would also take back. So the investors, even though a $10 million deal is a pretty bad deal for a company that's supposed to be 15 million, that's not something that VCs invest in. They're still actually going to walk away with some money, because it's the 5 million. They take the 5 million off the top and then get 1/3 of 5 million. So these are the really important terms, and the two things I always look at immediately is, liquidation preference. I look at that really hard. I want to know exactly what we're talking about. The board composition, and maybe the anti-dilution provision. Those are like the most important terms, except of course, again, the valuation. What do we find, again, in the certificate of incorporation? Really is the most important, sort of the mother of all documents. It will have dividend provisions in there. And here's maybe one other term that we don't see a lot, but there are differences in dividend provisions. There's something what we call a cumulative and a non-cumulative dividend, or sometimes accrued dividends. This is pretty important, because if you have, for example, let's say a horizon of an investment of 7 years, and you juice your return with a cumulative dividend of 8%, you can see that that is quite an additional add-on for the liquidation preference that an entrepreneur will need to leave on the table for the investors. If it's a non-cumulative dividend, it's actually a pretty nice term, because it means if there is one declared, if the board ever declared. By the way, I know there are almost no emerging growth companies that declare dividends. Only in that situation do we get a preference, which is a 7% or 4%, 5%, 8%, whatever it is. Other important thing, again, as I said earlier, is the anti-dilution provision. Well, here, again, Silicon Valley, that's the beauty of Silicon Valley. Silicon Valley is actually, VCs here understand that this is not a play where you just protect your downside constantly. This is really a situation where, you don't want to look like a fool in front of your LPs, so you have to have some protection if someone comes in later and gets a much better valuation. But full ratchet, please. I mean, think about it. So you sell, let's say, your company at $1 a share, and company really doesn't do well at all, and ultimately you have to sell the next round of shares for 33 cents or whatever, like 1/3 of the original price. Full ratchet means that everyone's going to get ratcheted down to that amount. Well, that's pretty bad, right? And ultimately, it only leads to carve-out plans. It leads to all kinds of stupid, arrangements that don't really make sense. So clearly, weighted average, and especially, frankly, broad-based weighted average is the norm, and is something that most people use, and most VCs are comfortable with. And I could go into formulas, actually mathematical formulas, but I'll leave that. You can look at that I have some materials on that if you're interested in that. Then the other really important thing is director voting rights. So I had an entrepreneur one time come to me and said, I got a great term sheet. I got a $10 million pre-money valuation, and they're putting $4 million in, and this is great. So, of course, we looked at liquidation preference. It was like 3x liquidation, participating preferred liquidation preference, because the VC said, well, if you want such a high valuation, I can give it to you, but here's that. And by the way, we're going to control the board. Or there's like a Mexican shootout scenario, 2 and 2, and and you have to have the third one, or the CEO gets appointed, but only as long as you're the CEO. There are a whole host of different things that you can put in there, where basically the VCs can take control over the board. And by the way, at one point, you are going to lose control over the board. I mean, in very unusual circumstances, you don't, but maybe you shouldn't lose it in your Series A. That's all I can say. And then the protective provisions are things that really bug the hell out of entrepreneurs, but are actually, frankly, quite common and also quite fair in many instances. What you want to avoid as a VC is that you put the money in, all of a sudden the company just takes the money and runs and changes, like it's a gaming company now, all of a sudden we're doing bicycle development or whatever. clearly you can't do that. Certain things you're not supposed to do, or you change change the capital structure of the company. You can't do that. Those are the types of things that are typically in the protective provisions. What you have to be careful as an entrepreneur is that the protective provisions don't really change your behavior on the operational side. If you have to run back for every $10,000 to the shareholders, and I'm not even saying like sometimes the board, but sometimes even the shareholders, that's really not something that people look forward to. One thing I want to mention very quickly, but I'm not going to get into it too much. There's redemption rights. There's also pay-to-play provisions, but that's more an issue for investors. But redemption rights are sometimes difficult because first of all, there's a huge accounting issue. If you have redemption rights, potentially the whole transaction is actually looked at as a loan. And redemption rights are not something that people really look forward to on the West Coast, especially on the East Coast. You have to be prepared to see redemption provisions. So that means after a certain amount of years, they can come back, investors can come back to you and say, you know what, thank you very much, I want to have my money back. And I can tell you, I've only seen it twice in my whole career, and I've done a lot of deals where it actually happened. And this is a situation where the company's doing actually well. It's it actually cash is not an issue. It makes cash, but it's just not a venture-backed company. It's not a company that has a trajectory that goes like this. It's just a steady business. Throws off some cash, and then the investors say, you know what, I'd like to get out. I think, Stas, how much time do I have? I'm almost done. I'm out of time. I know, and so in the presentation materials, there's a lot of further information about some of the other agreements that I touched on very early on, but we only have a half an hour, and I'm the only one standing between you and the lunch, and so I hope you enjoy the rest of the day, and if you have any questions, please let me know.
Copies on the front.